Good morning, everyone, and thank you for joining us. My name is Ana Maria Studer. I'm the Advocacy Support Program Manager here at Standpoint. This webinar is being recorded and it will be available on our Standpoint's YouTube page afterwards. The link to the recording will also be emailed out to our legal advocacy listserv. My role today is to help facilitate the webinar. I will put the link of the PowerPoint in the chat box to make it easier for you to follow along. If you have any questions, please put your question in the Q&A box and I will pass it along to the presenters. Most of you probably already know about our organization, but for those who don't, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls through our action line. Examples of the trainings that we provide are the new laws training that we provide every year throughout the state of Minnesota. And just to let you know, we're getting ready to start this year in August. So please check your emails because we already sent the save the date email out. If you don't have it, you can contact us and we can send it to you. We also provide the monthly webinars like the one we're providing today and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors and our advocates connect callers with resources. We provide safety planning. We listen and help callers identify possible options and next steps. Now I'm going to introduce our wonderful housing team, Raylene Caswell and Bailey Hovland. Bailey Hovland joined Standpoint in December of 2024. She graduated from the University of Minnesota Law School, where she represented detained immigrants as a certified student attorney through the Binger Center of New Americans, and earned a concentration in family law. Bailey also externed for 2 district court judges in Ramsey County and clerked for the Honorable Kevin Miller in Otter Tail County. Following her graduation from law school, she has considerable experience representing clients in both family and immigration law cases and previously worked for the Feminist Majority Foundation to promote gender equity in reproductive health care. As a staff attorney with Standpoint, Bailey advocates for survivors, providing legal advice in Title IX, family, child protection, termination of parental rights, housing, immigration, and other matters that intersect with domestic and sexual violence. Raylene Caswell is our housing advocate and supervising advocate. Raylene, her, began her work as an advocate in 2009. She has focused on housing stabilization, crisis intervention, shelter work, hospital-based advocacy, program development, and volunteer management. She is passionate about promoting the wellness and resilience of advocates in the field. And now, join me in welcoming Bailey and Raylene, presenting Supporting Economic Mobility for Victim Survivors, our housing edition. So welcome.
Awesome. Thank you so much, Ana Maria, for that great intro. And just another plug for New Laws. I know Ana Maria has been doing lots of good work to get us prepped and ready for that. So definitely check your email and hopefully we'll see you in the fall. Today, you are hanging out with me and Bailey to talk about advancing economic mobility through housing law. And I think it's a topic that we've been thinking about for quite a while because we know that one of the biggest things that victim survivors need when they are fleeing domestic violence or sexual violence is money, essentially. And being your housing team, we're going to do that through the housing lens today. So we'll kind of get us started and note that this is not a full training on all of these topics. So we're going to do kind of high level intros to different things like eviction, expungement, mobile homes, things like that. And then as you have questions, again, you're always welcome to put them in the chat here and we'll get to those throughout the presentation and then reach out to us. We can always dive in a little bit further on the phone. So as Ana Maria said, You probably already know a little bit about Standpoint since you're on our listserv and found our webinar, but just to kind of reiterate, we've got attorneys that have different specialties in lots of different areas of law. We know that domestic and sexual violence touch so many different things, and so our attorneys are able to answer lots of questions on lots and lots of different topics. So we're really proud of that. And then I don't know who's in the crowd with us today, but lots of advocates probably. And you kind of know the work of advocacy. So lots of safety planning, referrals. We make lots of referrals to all of you and focusing on legal advocacy. We are statewide, which is fantastic, and we are free regardless of income, which is actually really important thinking about economic mobility as well. Not only because it's free, but we don't have any income caps. So we can work with anyone, even if they have a very high income. So I just like to plug that as well. I'm pretty proud of that too. So, what is economic mobility? Essentially, economic mobility is the ability to improve your economic status over a certain period of time. We know that lots of victim survivors have experienced financial abuse, and that can often interrupt or disrupt any kind of economic mobility they might have been working toward. So there's a couple of different ways to think about economic mobility. We can think about absolute mobility, which is when we think about that, it's probably when we think about economic mobility, that's probably what we're mostly thinking of, is the changes to the economic capacity of an individual or a household. So that's typically what we're kind of thinking of. Maybe someone gets a raise, wins the lottery, gets a new car or something like that. That's kind of often what we're thinking of, and that's going to improve your economic status. There's also relative mobility, so how people are doing economically compared to other people in different economic distributions. We also think about intra-generational mobility, which is the change in an economic status over the course of an adult's working life. So between ages 25 to 64, according to the folks at UW-Madison. So thinking about how are you moving from one economic status to another within your lifetime, within your working lifetime. And then there is also intergenerational mobility. So how does your economic status compare to that of your parents? So how did you move up in economic status? Did you stay the same compared to your parents? What does that growth or otherwise look like? So those are kind of some of the different ways that we can think about economic mobility. Again, we are probably focusing on that absolute mobility. We're working with people that are in crisis. We just need money and we just need to figure it out. So that's probably kind of what we're mostly dealing with. Ideally, kind of thinking about a working adult. Typically, they are moving up in economic mobility throughout the course of their lifetime as they're working. We start out doing retail jobs, we move into office jobs, we move into higher positions in companies and things like that. So oftentimes we are increasing our economic mobility. Obviously, that depends on, kind of the economy at the time, different political things going on, obviously people's identities and how different systems of oppression interact with them. But also, in our situation, how does financial abuse play a role? So that is really what is being interrupted here. Yeah, so that's kind of some intro on economic mobility. So, when we think about economic mobility and housing, I'm sure all of you know all of these things already, but there are lots of different things that impact our housing. First and foremost, as I mentioned earlier, systems of oppression. And specifically when it comes to housing, we think of the unfortunate legacy of racism and redlining. And this was a practice of essentially um, really high level explanation of just making sure that people of certain races were not able to buy housing. And covenants in a home when they were being sold would say, hey, you can buy this home or you can sell this home, but it has to be to someone who's white. And so it really focused on keeping white people in certain neighborhoods and people of color out of those neighborhoods is really what that was focusing on. It's a really fascinating and interesting topic. I definitely encourage you to go read some more about it. If you own a home, check your deed to your house, see if you've got that. There are projects that can help you rectify that if you have one of these covenants in your housing deed, so check that out for sure. Then when we think about housing, we also think about poverty, and not we are working with lots of people that are experiencing crises, but even at the time where someone might not be living in poverty, domestic and sexual violence have an impact on their financial ability. So thinking about long-term poverty, situational poverty, or current poverty, thinking about someone who might be married but doesn't have any access to any of the funds. So essentially just not having access to income, even if it was there. We also know that there's a housing shortage here and in many other places across the world. And connected to that is unaffordable housing shortages for sure. We know lots of fancy condos are being built and things like that. And when people talk about advertising affordable housing, sometimes it's just not affordable at all. People don't have access to programs like Section 8, and the wait lists are super long. And that housing assistance is super, super limited. We all know that. You've all engaged with those systems, and it can be really, really hard to help somebody find housing. Something that can make housing even harder to find is if someone has an eviction on their record. And a lot of times they don't know that they have evictions on their record. So I always encourage you to check that out when you're working with folks. But eviction records prevent people from getting into housing. Or sometimes a landlord might require a double damage deposit or first and last month's rent and things like that, or require a co-signer, or just choose to not rent to them at all. So that most of the time, evictions are happening for folks for non-payment of rent. I think it's like 95% of evictions in Minnesota happen for that reason. So that means that people who couldn't pay for their housing one time around are forever penalized because it's going to be even harder for them to find housing going forward. And then sometimes there's just inadequate social supports. So people don't have access to all kinds of other resources that allow them, or that don't allow them, excuse me, to prioritize finding housing. People have car repair issues. They don't have access to food. They don't have access to good transportation, all kinds of things that I know you all like face every single day with the folks that you're working with. And there's tons of other issues that impact housing as well. So we know that focusing on economic mobility and access to money and housing that makes sense for people is super important. Additionally, we kind of have this double-edged sword when it comes to domestic and sexual violence and housing instability. We know that people that are experiencing domestic and sexual violence, because of that experience, have to flee, or something like that, and they then could experience that housing instability. They might start staying with friends and family, they might be staying in hotels, and that's just not stable. And they're working hard to find somewhere to go, but because of all these issues that we've been talking about, finding housing is really, really difficult. So the other part of that is that people that are experiencing homelessness or unsheltered are at higher rates for experiencing domestic and sexual violence. So we have to kind of come at it from both of those areas. And again, you all know this, you've all experienced this, but this is why talking about economic mobility for victims and survivors is so important, and that why we need to prioritize housing stability can really help people feel, again, safe is the first and foremost thing, but can also really help upward economic mobility for their immediate situation and kind of going forward. Obviously, we all know this, but let's talk a little bit about housing law can make that happen. And I will turn it over to Bailey.
Awesome. Thank you, Raylene. So yeah, that was a great overview, kind of giving you of why we focus on this topic. Raylene and I have had many discussions on the issues that we see on the action line every day and how so many of these issues could be prevented if people had access to better financial resources or knew the remedies to preserve their current financial situations and circumstances, specifically in relation to housing. So we're going to be walking through different possible remedies and issues you might see, I should say the other way around, different possible issues and then remedies you might be able to use to address those issues when clients come to you and are seeking help with different housing issues. So we can go to the next slide, Raylene. Awesome. So when we get a call on the action line and we flag a housing question, immediately Raylene and I are thinking about very different things depending on the housing question that we get, right? And different types of housing require very different considerations from a legal perspective, as well as from safety planning, because some remedies that are available for types of home ownership are not available for rental units that people live in. So these are some of the questions that we might face when we are thinking about how to help and provide advice and planning to a client. So with home ownership, immediately I'm thinking, who is on the title? Who is on the mortgage? Are the individuals who own the home married? Is a tenancy created between the individuals? Who's paying the mortgage? What are the current living conditions within that home? Has a foreclosure process been started, right? These are very specific questions that are coming up and going through our minds when we're trying to figure out what kind of situation are we dealing with and what remedies might be available to this individual. The same thing goes for when we encounter people who are living in apartments or other types of rental units. Is there an active written lease? Who's on that lease? Is there a tenancy at will, which means that there isn't a specific tenancy named in a lease, but that they are considered a tenant under the law? Who pays the rent? Is it a subsidized housing unit? Because then a lot more federal implications come into play. Has a tenant been certified under VAWA, which is the Federal Violence Against Women Act? Has the tenant terminated their lease under Minnesota Statute 504B206? These are all things that we're thinking of. With manufactured/mobile homes, and I will be referring to those two things as if they are the same, just because I know a lot of people will refer to them as mobile homes rather than manufactured homes. But again, who is on the title? Are there any outstanding loans on the home? Is the mobile home affixed to the lot or attached to the lot? Is there again a tenancy at will? Who is paying the lot rent? And finally, we've encountered this quite a bit more frequently this past year, but contracts for deed have come up. And again, the questions that I'm thinking of when we get a call about a contract for deed is who's on the contract for deed? Who typically makes that payment to the seller? Have there been any missed payments? And that is a huge part of contract for deed issues that we see is that last question. Have there been any missed payments? You can move on along.
I'm gonna pop in first, actually. But when we are working with victims and survivors, they often don't know the answers to a lot of these questions. Documents have been withheld from them, documents have been kept from them. Sometimes they've been told one thing and they find out the other. And that's all part of a system of financial abuse. So sometimes our work has to start with, hey, you have to find the mortgage company and call them. You have to see if you can find the deed. You have to do a little bit more research first. And that can be really hard and really scary for a lot of victim survivors because maybe the paperwork is in the home and that's where the abuser lives or something along those lines. So there's a lot of this stuff just doesn't make sense to people, when we're thinking about home ownership. There's so many things that people just sign when they buy a house and they have no idea what they're doing. And that's normal for most people. But when it comes to domestic and sexual violence, victim survivors, they might not know, or they might have been forced into signing or not signing something.
So first, we're going to talk about home ownership and what that relates to. So this is usually the most common thing I think that comes to mind when people are talking about housing issues. It's either this or rental assistance, right? But um, jointly owned homes are a common issue that we face. Now, one of the first questions, so in my prior work, I was a family law attorney, and I do give family law advice over our action line as well as housing law advice. But one of the biggest questions that I have to establish first when we're talking about a jointly owned home is what is the status of the parties, the legal status? Are they married or are they unmarried? Now, if they are married, the proper way to divide their interest in a home is either going to be through a divorce case or a legal separation case. Those kinds of cases are similar, but legal separations are less permanent. Divorce cases are much more permanent, so that is something to note. But if they are married, like I said, those are the two remedies that they will be likely having to go forward with if they are seeking to get their equity out of that jointly owned home. If they are unmarried, then the proper action would likely be a partition action, and that is dividing equity up in a jointly owned home. A partition action can happen between essentially anyone who has property interests in the same piece of land or in the same residence. And so that could be between couples, could be between a parent and child. It can be seen in a lot of different ways. It really depends. But like I said, for divorce, there's a specific process, as is there in legal separation. Partition is the correct remedy, though, for people who are not married to one another. So the first thing that I am wondering about is who has title when I hear about a jointly owned home? Who is on the title? Now, if you are married, even if you were not named on the title, you may have an interest in the home because it likely gained equity during the time of your marriage. And so even if you don't own an equal interest, if the other person bought the home prior to the party's marriage, there's an argument that there's legal equity in that home. However, if you are not married and your name is not on the home, that is a very difficult place to be in. I did put in the unmarried section that a breach of contract action might be possible. So perhaps you're unmarried, you're not on the title, but you reached an agreement that I would put a certain amount of money into this home. They would qualify for the title because their credit score is better. And then all of a sudden they say, screw you, I don't care. My name's on the title and you can't do anything about it. You could sue for a breach of contract, could be unjust restitution. There's different legal remedies that might be available to you. But again, it really depends on that title. If the title is in both people's names, they have shared ownership interest in that home. Now, the amount of ownership interest is going to be determined by a court, either through one of those legal actions we just named, partition, divorce, or legal separation. But if both people are on the title, that is typically the easiest way to see that someone has an ownership interest in a home. If one person's name is on the title, that's where things get a little bit trickier. Like I said, it's likely that that person might not have an interest unless the parties were or are married. Again, there's a possibility you could bring a breach of contract action if you put significant money into the home and are being unjustly deprived of that financial equity, but it's going to be a tougher case than if your name was on the title or if you were married to the person whose name was on the title of the home. Another thing we're looking at is whose name is on the mortgage. Is it joint or is it in one person's name? This is not as dispositive as title, but can be used as evidence to support a claim for equity or an interest in the home. So if your name is on the mortgage, it's easier to claim, no, I do have an interest in this home. I was paying towards the equity of the home. And you can see that by my name on the mortgage and the payments I made from my credit card or my bank account. So that's something to discuss with victim survivors to see if they put equity into a home that way. Again, jointly owned homes, the biggest issue is who has equity here. Is it joint or is it attributable to one party? There's a bunch of different factors that go into this analysis. Number one, again, is are the parties married or not? Number two, have there been any improvements on the home? That could include updating a water heater. It could include plumbing issues. It could include adding a fourth bedroom with a contractor, right? Improvements on a home are likely going to be more substantial, right? If you just replace the shower head, that is likely not going to gain you any equity in the home unless it's a very expensive, very important shower head. But improvements such as like building onto the home, fixing essential things within the home, those would likely go into the factor of equity. Same thing with who made the down payment on the home. Who was the one who wrote the initial check or got the loan? Who is the person who put the money forward to buy the home, right? That is an important analysis and a factor in who has equity. Who makes the mortgage payments on the home? Is one person consistently paying the mortgage? Are they Venmoing one another for half of the value of the mortgage to put in there? How are those mortgage payments made? How are they traced? That's an important thing to analyze and look at when you're talking about equity in a home. Finally, any loans that might be on the a home. I put HELOC there. That stands for a home equity line of credit. That's a line of credit you could take out on your home. That's the most common one you come into, other than obviously mortgages for loans on the home. But again, is that equity affected by a HELOC? Have both people sign the HELOC? Did just one person sign the HELOC? These are all things that we're considering and analyzing when we're trying to establish who has an ownership interest in a home. Right. So then next we're going to talk about some home issues that we commonly see and possible solutions or remedies for those issues. And I've talked about a few of these briefly, but we're going to keep covering them because I want to make sure we're covering the full breadth of these issues. So number one, a dispute regarding equity in the home, right? Two people are saying we both have an ownership interest in this home, we both have equity in this home, and I want to claim it. I want it. The solution for married couples is divorce or sometimes legal separation. Again, legal separations are not very common in Minnesota, but they are a possible remedy. So just flag that in case you ever have a client who is interested in learning about that. Otherwise, a partition action is going to most likely be the solution if you have unmarried people asking about equity in a home. There are also safety concerns with jointly owned homes. We see a lot of these from a day-to-day basis, obviously, because victim survivors frequently have safety concerns when they are leaving their abuser or dealing with any financial issues with their abuser. So some things that you might be able to do in a divorce case is you can actually move the court or submit a motion to ask for one person's exclusive occupancy of the home. That means one person is allowed by the court to be in the home during the divorce. And so you can ask for that by motion. Um, it is not a remarkably difficult process. You really do have to establish why one person should have exclusive occupancy, how they will maintain the home, take care of it while the divorce is pending and the party's equity in the home is being determined. You could also ask for an order for protection with the home and name the home as the survivor's protected address, right? And that would exclude an abuser from the home, even if they have an ownership interest in the home, even if they have title to the home, they might be able to pursue other remedies later to try to gain access to that home. But again, the order for protection would be that prohibiting first step to allow a victim survivor to feel safe and to make sure that that residence is protected and a safe place for them to be at that moment in time. Another issue is non-payment of home expenses. This is very frequent when we're talking about financial abuse, where an abuser will withhold payments for utilities for households when they are going through any kind of legal action, or even when they're not going through legal action, when they're just trying to inflict harm upon a victim survivor. In a divorce case, you could submit a motion for temporary support. And that could be called family support, that could be called temporary spousal maintenance, right? There's a few different ways of looking at it. But essentially, you could ask the court for someone to pay the victim survivor. That someone would be their significant other in the divorce for temporary support to maintain their status of living and to maintain the party's assets, which includes home. And typically, divorces, when they're talking about home equity, homes are one of the biggest sources of equity for married couples when they're navigating through a divorce. Again, another option would be partition. Now, this one is a little bit more frustrating for a lot of victim survivors because frequently they call and they say someone has not been paying the expenses on the home, they refuse to pay the utilities and the electricity has been cut off, or they are refusing to pay the mortgage and the mortgage company is starting to get up in arms and are starting to talk about foreclosure. I don't want any of that. It's hard to force someone to pay those things if it is not through a divorce case because there's not necessarily an established legal relationship between the victim survivor and the abuser. However, you could initiate a partition action that would divide your interest in the home. There's always the option to settle in a partition case, and that settlement may include the victim survivor being able to stay in the home for a longer period of time or even for being able to stay in the home until it's sold and then the equity would be distributed between the abuser and victim survivor. But often people are frustrated there aren't other ways to force someone to pay for a home while financial abuse is ongoing if it's not through a divorce action. Another issue we commonly see is an eviction from a shared home. Now, if we're talking about evicting an abuser, right? If a victim survivor is contacting us and they are looking to oust an abuser, you would either have to do a notice to terminate a tenancy at will, and that's if the abuser does not have an ownership interest in the home, right? So if the victim survivor is the homeowner and they've been living with their significant other who is their abuser, and they're trying to figure out how to get their abuser out, you can evict them. It would be considered a tenancy at will, so they would have to give notice, but technically you're just ending their right to possession of that home under the statutory prescribed guidelines. And there's no problem with that. The only problem that comes up with safety planning is obviously there's a period of time you have to wait to initiate an eviction action. And so you'll want to do some safety planning with a victim survivor for that interim period where there was the notice to evict and the notice to vacate, but they're having to wait for the legal process to begin under the statute timelines. There's also a way to protect survivors from abusers' attempts to evict the victim survivor in housing court. Now, one very important thing to know is that you cannot terminate a lease solely on the basis that the tenant or authorized occupant has been a victim survivor of domestic or sexual abuse. That is prohibited by Minnesota law. That applies to abusers who are attempting to evict victim survivors. It applies to landlords who are attempting to evict victim survivors, even if the landlord doesn't have necessarily role in that abuse, right? Even if they're just saying, well, I don't want these problems at my property, that's not a good basis to evict someone, and it is an easy defense to bring up in court. Raylene and I have both seen that people attempt to utilize someone's status as a victim survivor as a reason to evict them. It's not a legitimate reason under the law, and the landlord could be subject to damages if they pursue that remedy. Also, foreclosure. This is a big issue that faces people who jointly own homes, especially if someone is not making payments on the mortgage and the mortgage lender decides to initiate foreclosure actions. So foreclosure is a difficult process. It is a long process. You can potentially address it prospectively in a divorce. So, some potential remedies you could ask for in a divorce action, like we talked about before, temporary support requiring payment of the mortgage. I have had divorce court orders that specifically say one person is supposed to pay the mortgage on the home until further court order. And if they don't, that could be a violation, that could result in conduct-based attorney's fees. It could even result in contempt if it's extreme enough, right? So that could be a possible remedy. Again, temporary spousal support. So instead of saying you specifically have to pay the mortgage on the home, the court could say to someone, you have to pay your spouse this amount of money, which is to help with their standard of living, including they have to pay the mortgage expenses with that money you're giving them, right? So that's a possible option for victim survivors from their abusers. Sale of a home, right? Let's get the home sold and let's get our equity out of it. That is definitely something the court is able to do in a divorce. I have seen it happen many times following divorce trials where a court says, I don't know that I'm able to award it to either party, but I know I can order it to be sold and I can divide up what the equity in the home is to both people so that they both get some equity to move forward. Um, Foreclosure processes are very difficult, like I said. So sometimes if you have limited equity in the home and you want to avoid foreclosure, sale of the home is the only remedy to really pursue before foreclosure happens to allow people to get some money out of it and to satisfy the mortgage lender. It's obviously not ideal for many people because many people would wish to stay in their home and to remain living there. And sale of a home obviously would allow the property to be sold and nobody from the relationship would be residing there anymore. Finally, if foreclosure proceedings are pending because one person is not paying the mortgage, a victim survivor could offer to refinance the home in a divorce process, right? So they could go to a lender and say, you know, here is all my financials. What am I able to qualify for? Can I refinance the home on my own? And in doing so, they would likely have to compensate the abuser if they have an ownership or equity in the home some money. But again, if they refinance successfully, it would be all under their name instead of the abuser's, and they would have paid the abuser out for their equity in the home, leaving them with clear title and no future issues to deal with that abuser. If people are unmarried, like we talked about, the partition action is likely the remedy. However, you're going to probably need to file that partition action before foreclosure proceedings are initiated. As I said before, foreclosure is a long process, but while foreclosure proceedings are going on, other legal proceedings will likely be immediately suspended. So that means that the foreclosure process is going to be looking through all of the debts of a person, going to be looking through that mortgage and seeing what's happening. And there's not a lot you can do in court otherwise while that's pending. So any action that you'd want to take in partition, you'd want to take before foreclosure proceedings were formally initiated. All right, we can move on to the next slide. I think this is you, Raylene.
Yes, it's my turn. So we're going to jump into renting. That's where most of my experience has come in this work and where lots of advocacy experience is for sure. The majority of folks that we are talking to here on the action line rent, whether it's a formal lease through like a regular landlord kind of situation, or they are paying someone money to stay in their home, more informal agreements, lots of different things going on with that. So when we were thinking about victim survivors who are renting, there are, of course, many concerns when it comes to their safety and kind of options that they have. So first and foremost, obviously safety concerns if they are living with an abuser. If they're living with someone who's unsafe to them, obviously that's definitely not good. But we know people stay in those situations because housing is so limited and money is so scarce these days. So some things that we're thinking about often is an early termination of the lease or a transfer request, and we'll get into that a little bit here in just a second. We also talk with lots of victim survivors who experience privacy violations from landlords or other building staff. So the maintenance person coming in to make, to fix something and not giving proper notice, things like that. So that kind of stuff comes up quite a bit as well. And then we also talk a lot in renting about what it looks like to evict an abuser. And then another big one is damages caused by domestic or sexual violence caused by that abuser or an abusive incident. So first, something just to touch base on is if someone is renting and they are not safe in that home, whether the abuser lives with them or knows where they live, or something along those lines, they have some options to essentially stop renting, and move somewhere else. So we have two ways of doing that. The first one is through the Violence Against Women Act, and that's a federal law, and it applies to everybody. The women is just a kind of a carryover of old language, but that is a federal statute that applies to everyone who is renting in federally subsidized housing programs. And then we also have Minnesota Statute 504B.206. And a lot of times we kind of mush these into one, a lot of times, but the processes and kind of options that are available are super different. So just from a high level overview, when someone is renting and they don't want to be in that home anymore, the questions that I'm asking them are first and foremost, do you live in federally subsidized housing? I might say it differently than that, because I might say income-based housing, Section 8, tax credit properties, things like that to try and jar people's memories or kind of understanding, because federally subsidized doesn't really mean anything to anyone. So trying to find out, do they live in one of those kinds of programs? If so, then we want to look at the Violence Against Women Act options first. There are some protections for tenants who have been victim survivors of domestic and sexual violence and dating violence and stalking. While VAWA does not break a lease, it can initiate an emergency transfer. So the victim survivor can say, hey, I'm not safe in this unit, but I would be safe in another one. Can you help me get to that one? And that is a really good option for people. There is also the option to bifurcate the lease, essentially. So that means a process of removing or essentially taking the one lease and splitting it into two. So the victim survivor would be in one housing unit and the abuser could be in another. Those are kind of the housing options under VAWA. There's lots of other things, but essentially in terms of moving, that's what VAWA can help with. There are also other protections under VAWA for folks that are applying for housing. They cannot have domestic or sexual violence kind of count against them. So if they have poor credit because of domestic violence and financial abuse, they have to take that into consideration when applying for federally subsidized housing programs. They also cannot be evicted for violence that they've experienced, and there's other protections to help them stay in that housing. But I think the biggest takeaway with VAWA is that it only applies to people that are staying in federally subsidized housing programs, and it doesn't break a lease in the same way that we kind of think about it. It will either move them to a new unit or remove an abuser from that home. Now, keep in mind that that process definitely takes some time, so you have to do some really good safety planning. And because the housing programs have to take into account what is your voucher, what kind of subsidy do you have, what kind of housing is available, when is it available, and then let's say that the first unit that comes available is the one next door to the one that you currently have. That might not be safe. So it does take some time to find a new unit. So definitely do some really good safety planning there. So VAWA is really good. If you have questions on that, definitely feel free to give a call. The process itself is very simple. The person just has to certify as being a victim survivor with Form 5382 is the HUD form that you can use specifically to do that. And it's something very simple that the victim survivor can fill out, or you as an advocate can fill it out for them as well. It's very simple. It used to be a lot more complicated, but they've recently updated that. So that can be found online. And once Bailey's chatting, I can throw that link into the chat there too. And so that form is really simple, really easy to do. Now, if we're thinking about people that live in kind of market rate housing, so someone who is renting from a local landlord, they don't have any kind of housing subsidy or housing programs available to them. They're paying, $1,400 a month for their rent or whatever that might be. The option for them to break a lease is only through the Minnesota statute. So they are using Minnesota Statute 504B.206. And this allows a victim survivor of violence to break their lease due to that fear of domestic or sexual violence, harassment, or criminal sexual conduct. And essentially what it does is it means that the victim survivor gets to break their lease. They don't have to give a certain number of days notice like most leases require. they do have to give notice to their landlord, and they do have to provide some kind of documentation of the abuse, which is most of the time a qualified third-party statement, something that most of us are pretty familiar with. And once that is provided to the landlord, their lease is considered broken as of the day that they put in their notice. I can also put in the chat the kind of checklist that we've created to help people navigate that process, and that can make it a little bit more simple. The big things to think about with this is that with the Minnesota statute, the victim survivor does automatically forfeit their security deposit. And I think I might be frozen. Am I back? Am I here? I was frozen. So sorry.
No, you're
Okay.
fine.
I thought I was frozen. Anyway, I'm sorry. Bailey, heads up, my internet might not be great, so you might take over for me. But the biggest piece to keep in mind here is that the victim survivor does forfeit their security deposit, and that is a huge bummer. Don't love that, but unfortunately, that's where we're at. So that's something to really make sure that you're talking about with folks. The other thing that I like to talk about as well as it relates to economic mobility is, hey, what kind of damages have happened in your unit, and was it because of domestic or sexual violence? Because while if you break your lease with the Minnesota statute, you're not responsible for any rent kind of going forward or anything else like that, you are responsible for any damages in the unit, any past due rent, and things like that. However, if there has been damage due to domestic or sexual violence, then we need to let the landlord know that. And so I'll often tell people, make sure when you're moving out that you're taking lots of really good pictures, you're documenting the damages that have happened when it's safe to do so. Sometimes we're just kind of fleeing, and that's a different situation. But if detailing so the landlord knows, hey, the hole in the wall in the kitchen was because of domestic violence, but my cat ruined the blinds. So like I get that I have to pay for that. As a person who has had to pay for that before, like I get it. So really being having good conversation about that. I know it's not always possible to do that because sometimes we are just running away from that place and just getting safe. But if and when possible, it's a lot easier to do that proactively than after you've already moved out. So I think that's kind of a super high level VAWA versus Minnesota Statute 504B. Just again, keep in mind VAWA does not technically break a lease, and it's only for federally subsidized housing programs. Minnesota statute applies to anyone, and you do lose that security deposit. The paperwork for both of those is super different, so just make sure you know which paperwork you're using. VAWA is Form 5382 through HUD, whereas the Minnesota statute uses the notice to landlord and a qualified third-party statement most of the time. So that's kind of what you're looking at for those two. So I think that's a big overview of those things, but I love talking about lease breaks, so always call me. It's one of my favorite things. Okay, so when we're thinking about potential remedies for folks that are staying in rental units, whether again that's an official lease is created or they have been a tenant under the law, the first thing that we as advocates are always thinking about, of course, is safety. That is kind of our bread and butter. That's what we're really good at, and that's definitely what we want to have happen. So we want to look into an order for protection, or we can look into an order for protection, excuse me. It's obviously not right for everyone. That can exclude someone from the home. That's often the first thing that we're looking into. You could also look into a harassment restraining order as a potential option as well. Sometimes it gets a little complicated because we have seen courts not grant an HRO for people that live together. It gets complicated and weird. Know your courts, give us a call. We can kind of talk that through. And then, like Bailey was talking about earlier, is that you can request for temporary exclusive occupancy or use of the unit in a divorce case. So that is definitely something to keep in mind. And then there it is. HRO cannot exclude a respondent from their own home. So yes, keep that in mind as you're navigating that. Obviously, if someone is in need of safety planning, an early termination of the lease under Minnesota Statute 504B.206 can be a really good option, which I just talked so much about that, so we don't need to revisit that one. Transferring an emergency transfer to another federally subsidized unit under VAWA, or the Violence Against Women Act, can be excellent. We're also working with lots of folks that are looking for reasonable accommodations based on disability under the Fair Housing Act. And this is something that is a little bit more complex and not really what we'll kind of get into a ton here, but that can definitely be something to explore in terms of keeping people safe. It does have to be based on disability. So the person that you're working with would have to have a documented disability to kind of navigate that process, but give us a call on that one. And then damages caused by an abuser, definitely something we talked about as well. The tricky part is the landlord is going to be mad about the damage no matter who caused it. And so what we often do is remind the landlord like, hey, I didn't cause this damage. I was the victim of a crime. You should go after the person who committed that crime and caused that harm. So you can, one, the landlord could go after the person who made the damage, essentially who caused that. And then you can also look into conciliation court. Conciliation court is not something that a lot of people explore in my experience, because it requires going to court and it requires documenting what kind of damage has been done, the cost of things, and all that kind of stuff. And when people are in crisis, it's not often the kind of remedy that they're looking for, but it does come up. And it comes up in terms of property as well, like getting property back and things like that from an abuser. So those are some of the things to kind of be thinking about when people are renting. The other thing to think about as well is evictions. And I think about evictions that have happened in the past, or evictions that victim survivors are facing now. So we got to kind of think about both of those things when we're talking evictions. But first and foremost, just again to reiterate, as Bailey said, evictions of victim survivors based on domestic abuse is absolutely not allowed. It's prohibited by the Violence Against Women Act and Minnesota Statute 504B.285. So this means that because someone experienced domestic violence it means that they cannot be evicted based on that experience. Now, landlords will try. They definitely will try that sometimes, and they will say, especially when I've seen it a lot when there have been like gunshots or like really excessive incidents in common spaces and things like that, they'll say, hey, you are experiencing domestic violence and you've put other tenants in danger, so now I have to evict you. We push back and say, hey, why don't we think about evicting the abuser? And there's a process outlined for that. So that is definitely an option that the landlord can explore. Now, that's hard to kind of talk through a little bit, so you can always reach out and talk with us a little bit more about how to have those conversations with landlords. But it is just a reminder that because this victim survivor experienced the abuse, they can't be evicted based solely on that reason. Now, again, the landlords might also say, hey, there is domestic violence here, but you're also behind on rent, so I am going to evict you for non-payment of rent. So there are other reasons that the person could still face an eviction, but if anyone is ever facing an eviction and we believe, or we are guessing that it's based on domestic violence or anything like that, give us a call and talk it through, because there's a lot of case-specific things to think through with that. And it's just not allowed. So we want to make sure that we're keeping victim survivors housed and safely housed. So then if someone is facing an eviction, there's a few legal reasons that they can be evicted, and there are a few defenses for each of those reasons. Generally speaking, and there's a lot of more like legal stuff to get into with each of these cases, of course, but if someone is facing an eviction, there are a few issues that can be raised. The defense to an eviction has to kind of match the reason that they're being evicted, or there has to be kind of some underlying issues going on. But if we're thinking about evictions, there's lots of new rules and laws about the kind of notice that someone has to receive. So the big change is for non-payment of rent cases, and people have to receive, Bailey, correct me if I'm wrong, but I believe 14-day pre-eviction notice is what folks have to receive, that the landlord is saying, hey, you're behind on rent, and I'm looking into eviction. So if within 14 days, I will file that eviction if we're not caught up and ready to go. So look into the notice. And definitely talk to Bailey about notice, because there's lots of different things that have to be included in notice, and for different kinds of evictions as well. But that's probably the most common one, again, that we'll see, just because non-payment of rent is kind of an easier eviction to file, and one that's harder to kind of get around because you can just show the math. But anyway, talk to us about notice. That's definitely something that can be raised as a defense in an eviction. We also talk a lot about retaliation. And this is retaliation in the legal sense, not what feels like retaliation. And that can be really, really hard to differentiate, especially when someone feels retaliated against, like they've been hurt and they feel that hurt, and they believe that their landlord is maybe discriminating against them, or maybe they think that the landlord has this idea that they're a bad person, or that they're just a problem tenant, or that they've experienced domestic violence, so they must be bad, things like that. But there is a legal definition of retaliation, of course, and it's definitely good to talk to us about for sure. But you can definitely bring up things like the habitability of the unit. So when we think about the tenets of habitability, we're thinking like, do they have access to hot water? Do they have electricity? Is there water at all? Are there some of those kind of main pieces of what we need in a rental provided for us? We can also look into discrimination. Again, discrimination is kind of complicated because what we know and feel as discrimination is not always legal discrimination, so that can be a little bit complicated. So as advocates, we can validate those feelings, and then Bailey can explain the law. That's how we kind of navigate that one. And then sometimes landlords are refusing to provide reasonable accommodations, and that's another thing to bring up as well. An example that I've seen is that someone had an accommodation that they needed a different kind of doorknob that they could use and open their doors with, but the landlord didn't want to change it because it wouldn't match the rest of them. So there's all kinds of different kind of accommodation issues that come up under retaliation. Generally speaking, we get lots of calls from people who say, my rights have been violated. And we got to figure out a little bit more about what that means. So in an eviction action, if the tenant's rights have been violated, that could be a possible defense against eviction, whatever that might mean. Again, people often feel that their rights have been violated. We just have to figure out which legal ones have been violated and what that means for their housing. Again, discrimination is definitely an issue to raise. If there have been past incidents with the landlord and things like that, that can definitely be a huge issue for sure. And then reasonable accommodations again. So an eviction based on retaliation or refusal to provide reasonable accommodations to the tenant. Again, there's lots of legal analysis in those defenses and things like that, but these are just some things that you can keep your eyes on in terms of an eviction action and when you're thinking about that defense piece. And again, always give us a call. So when we're thinking about the impact of an eviction, we know that it's long term. We know that the eviction stays on someone's record until it is removed through an expungement process. And we know that future landlords are looking for those previous evictions. So the way to take care of that and really promote someone's economic mobility, ability to stay housed and things like that, we look at expunging that eviction. So expunging an eviction just means removing that eviction from the record. Essentially, we're just taking that file, the court case information, and deleting it. And there are a couple of ways to make that happen. And this is kind of a very, very high level. We can definitely do more specific eviction expungement trainings, but it is just super helpful to know that there's kind of two main things to be looking for. So the first one is inherent judicial authority. So when someone has been evicted, it's been on their record, and they're looking to get it expunged, there are a couple of things that we can do under this argument. Is that first and foremost, we have to tell the court that this expungement is necessary and important as a judicial function necessary for justice. It's kind of legal jargony. That's the argument. The second piece is where we as advocates can get a little bit more involved in that process. We can talk about the expungement is going to be super helpful to the person that we're working with, and we can help document why. We've got some examples here about they can be more stably housed, they can provide for their children, these sorts of things. And that benefit is either equal to or greater than the disadvantages to the public not having access to that eviction record. So with a court case, with a court record, essentially there's lots of rules about it and things like that. But what it is saying that the public has a right to know about some of these things. And we've decided that that's really important for us. Future landlords, again, are using that information to determine who is a good tenant, for whatever that means. So that we're saying that this argument is that the benefit to the person is either equal to or greater than the disadvantage to the public not knowing about this incident, essentially. The last piece is that the expungement will provide a benefit to the person, again, either equal to or greater than the burden on the court in issuing, enforcing, or monitoring the expungement order. So again, this is where it gets a little bit icky of an argument, but we have to show to the court, hey, I, as a tenant, yes, I did not pay my rent. I acknowledge that. I know now that I need to take care of things. I need to make sure that I'm able to overcome the issues that were in this eviction. So the arguments get a little bit dicey there, but they don't always feel good. But again, we're playing the game to get that eviction off the record to promote that upward economic mobility. Then there are some permissive expungements that we're going to continue talking about. And the other argument is statutory discretionary authority. So this comes up sometimes, not as often, but essentially the initial landlord eviction case did not have basis in fact or law. So there had to be something with the underlying case that was wrong. Maybe the notice wasn't provided adequately. Maybe we can show that rent was paid. That's a common one that comes up actually. People where the landlord says, I didn't get your money, but the tenant can show like, here's a copy of the check that I gave you or the money order or whatever that means. And again, we still have to kind of show with the court as well that the interest or the expungement benefits the person, and it's okay for the public and for the court to take care of this. So that's kind of the high level things. Bailey, do you have other things to add to that?
No, those are both good overviews. Like we said, the court has permissive expungement authority. That means it depends on the judicial officer you get sometimes, and you have to prove to them why this tenant should have their record expunged. And a lot of it is basically advocating for the tenant and saying, the circumstances that occurred when the eviction happened are markedly different than this person's circumstances now. They've experienced extreme hardships, difficulty finding housing. Maybe their children that they house with them have suffered. Maybe they haven't been able to find stable housing for years. So you really do have to show that burden and then explain to the court, why is this good? Why is this going to help them? They're going to be able to maintain stable housing. They have a job where they can pay rent. Their kids will have a place to live, right? It's kind of making that case for empathy from the court almost. And the last factor of kind of making sure the public knows about the record, we have the public records are readily available in most cases, right? You have to show why it's no longer necessary that the public needs to know about this case, right? They're a good tenant now. They're a good renter. They understand the implications of what happened, like Raylene said. So those are the important kind of things to walk through. And Raylene and I are happy to talk through these expungement requests as they come up from victim survivors. But again, the most common authority is going to be that first legal argument, which is the inherent judicial authority. You're arguing the court just has the authority to do this. And so if it finds that justice requires it based on the factors, they should go ahead and do it. The second option is a lot more difficult because there needs to be that issue with the prior case. It can't just be that, oh, well, I don't agree with the landlord's iteration of what happened. It has to be either it wasn't allowed under the law or it was based on something completely untrue, like non-payment of rent, as Raylene said. And one final note, so there is a mandatory expungements piece of Minnesota Statute 5 or 484014 subdivision 3, but that is currently ruled unconstitutional by the Minnesota Court of Appeals. It is pending review at the Minnesota Supreme Court. They petitioned for review. So we're hoping to get a definitive answer on that to determine what happens there. But that is kind of the last thing that is known. And I see we have a question possibly in the chat, so I'm excited to hear what that might be.
Yeah. And I think too, we all know that eviction expungements are good. In terms of like a legal case, they're a lot less intimidating than you might think. And I think this is really where advocates can do a really good job because we can really help tell that story. So we're very accustomed to writing protective orders, things like that, and we kind of know what was going on for people, and we can kind of weed through how do we talk about the burden to the person or to the family that we're working with? And then we just use all the positive talk that we know how to do. We talk about all of the positive things that they've done. They know how to access community resources. They've, secured employment, whatever those kind of benefits might be to show that they're a good tenant. That can be super helpful. So this again is where advocacy can be super helpful in figuring out what that story is.
Yeah, and just so individuals know, I don't believe we can unmute participants just due to the setup. So if you do have questions, please feel free either to add them to the questions tab or to put them in the chat. We'll be responsive that way. But trying to go ahead and do that if you have that question. We're happy to answer it. We'll move along until I see that question pop up.
Yeah, I think the last thing that I would just say about evictions and expungements in general, there are lots of new laws about notice and things like that for evictions, but there weren't always. So I always recommend when you're working with someone on housing issues, look on the Minnesota court records online and see if they have any evictions they might not have known about. Before we had the 14-day notice, pre-eviction notice, for non-payment of rent, landlords would file an eviction all the time based on non-payment. And then if the tenant got caught back up, then the landlord would just say, "Oh, we're good. You don't have to go to court." But that eviction is still on their record. So sometimes that can be super surprising for people, and that can have a huge impact when they're trying to find housing later on down the line. So if you're able to help work with them to find that out, then we might be able, might be able to look into expungement a lot sooner rather than later as they're kind of navigating their housing situation.
And I'm seeing the question now. Yes, you typically do have to wait to apply for an expungement of an eviction on your record. It would not be 7 years. We actually just had a caller who reported today that after 2 years of dealing with their eviction, they had been granted expungement. So that's typically the period of time we recommend. Typically, that's what judges are looking at. There's no hard and fast rule that says you have to wait 2 years to apply for eviction expungement. The court just typically wants to see a period of time where this person has gotten back on their feet or there is such a burden to them. Typically, a month of homelessness is not going to warrant the court sympathy, which is really frustrating for people because that's a very difficult experience. And I don't mean to minimize that at all. But typically, you are going to have to wait a little bit. I would say at least a year, but 2 years is probably a safer bet. And again, it's entirely dependent on the circumstances and the arguments you're able to make. If you're able to make a very strong case that there is such an extreme burden on this person that they shouldn't have to wait 2 years and 1 year is more appropriate, you can make that request. But I would advise consulting with either a different housing attorney or calling us because filing for an eviction expungement and having it go unsuccessfully could deter later requests for that same expungement. So I wouldn't want to rush to file an expungement without making sure that the facts would support it that early on.
So when I am talking with folks who are looking to get an eviction expunged, I am typically asking questions like, when was the eviction filed? What was the legal reason for the eviction? What other circumstances were going on? Because we know like legal reason might be non-payment of rent, but maybe they were experiencing some pretty extreme financial abuse and things like that. So that can kind of impact our conversation. What county the eviction happened in, because counties are all different. You know, they are all doing who knows what. And then, does the landlord believe that the tenant owes money to them? And if so, how much? Because sometimes, if a tenant, the landlord says that the tenant owes them $10,000, that's going to be a really difficult thing for the court to kind of move on and make that eviction expungement happen. So there are, again, maybe there are some extenuating circumstances, but those are kind of the questions that I ask to start being curious about this process. And then I say, here you go, Bailey, and she does the legal analysis bit. So if that's helpful, you can always do that with the folks that you're working with.
All right, so I think next we're going to be moving on to manufactured or mobile homes. Um, so I'm going to go over this and overview. Manufactured homes in and of themselves are a very interesting niche area of the law. There's a lot of different rules that apply here that would apply to, the stereotypical home that doesn't need lot rent or anything like that and can't be moved, right? But it's a very niche area of the law. So just know that if you are dealing with a victim survivor who has a manufactured home, that it may be a very different process than what you might be expecting from a typical rent eviction action in an apartment or from a jointly owned home kind of case. So first and foremost, people who live in manufactured or mobile homes can either own their home or rent their home. They might rent it from another individual or they might own the home and just pay lot rent. And paying lot rent is only if they don't own the home where the manufactured home is located, right? If you have title to the land that the home is on and you also own the manufactured home or you're working towards owning it, right? That is also a total possibility. But if they do not own that land, it is very likely they're paying lot rent to like a mobile home park, right? And again, like I said, I'm frequently going to reference this as mobile homes. I'll use both, but under the law in Minnesota, they're traditionally referred to as manufactured homes. So just know that those things are considered often the same thing when we're talking about these issues. So the first question that comes up is whether or not the home is affixed or unaffixed to the property. Most mobile homes are going to be unaffixed. That's going to be considered personal property. It's different than real property, which is real estate, right? But if it's not affixed to the property, it would be considered similar to a vehicle, a trailer, something like that. Now, if it is considered affixed to the property, you're going to have to look at Minnesota statute section 273-125 to establish whether or not it is affixed. That is a very specific question that doesn't come up often because it's not very frequent that mobile homes are affixed to land, but just know that there are different legal rules depending on the designation of whether it is affixed or unaffixed. If it is considered affixed to the land, which means it's more permanent, it's established there and it's not moving and it's not mobile anymore, then it does become real estate or real property. The owner of that manufactured home could surrender the manufacturer's certificate of origin. That's essentially saying, I am surrendering this and the certificate of title for cancellation because the home is now an improvement to this real property. It is affixed to it, it is a part of the real property, and so we're treating all of this as one real estate property, not as a separate piece of personal property on top of real estate, if that makes sense. All right. So that's a general overview of the kind of first things that we're thinking of. Now, manufactured home repossessions are issues that come up for individuals who live in mobile homes often. This happens when someone defaults on a loan or defaults on a loan where the manufactured home was used as collateral, right? So either the manufactured home is under the loan and that's what you're paying off to gain ownership interest in it, or you use the manufactured home as collateral for a different kind of loan. That process is governed by Minnesota Statute 327.64, and there's specific language that is required for a notice of repossession. You have to serve it either personally upon a person, that notice, or via certified mail. And I put the language specifically here. I'm not going to read through it to save you all time, but just know that this is the language that is required for a notice of repossession of a mobile home. So if this language is not included, that is a big problem for the individual who gave notice and could be something for the victim survivor to utilize to fight the notice of repossession. Move on to the next slide. All right, so there are ways to cure repossession. It is not as if repossession happens and so long as it is proper, it's going through, right? We are giving people second chances to hopefully avoid a repossession. One is called the right to cure. So that's governed by Minnesota Statute section 627.66. This occurs within the 30-day repossession notice period. If you're past that 30-day period and the notice for repossession was proper, you're out of luck, right? But if we're within that month period, there are options to cure, and now these are the two possible options. One is you make full payment of the arrears, which is the overdue payments. This is hard for a lot of victim survivors, especially again if they're facing financial abuse, but if they're able to do it with a loan from a family or friend, that is something that would really give them an immediate assistance, and then the repossession notice would no longer be in effect. They would no longer have to worry about it because they've cured the defect. They have paid, and that is no longer an issue that is able to be brought before the court because the landlord, or I shouldn't say the landlord, because the individual is no longer suffering who is pursuing the right to repossession. Otherwise, you could try to remedy the default in other ways. If you can settle with the individual who gave the notice to cure repossession, settlements allow for a lot more creativity than sometimes the court is able to provide. And so if a victim survivor would be able to reach a fair settlement agreement, which again would be a time where it'd be good to reach out to Raylene and I to ask for maybe what are some creative options we've seen in the past utilized in that situation, that could be an option to settle and then dismiss that notice. I always advise as an attorney, I always advise getting these kinds of settlement agreements in writing, signed by both parties whenever possible. That way, you don't have to bring to the court the entire narrative of, well, this is what we agreed on, and I don't have any documentation of it, but this is what we talked about. It's really hard to convince a court of a conversation that you say happened when some other person is saying the exact opposite. It's a lot easier when you have a piece of paper that specifically says those exact terms with both of your signatures on it, right? So I always, always, always advise settling in writing with both signatures of the parties whenever possible, because it is a huge tool to help victim survivors and to make sure that people don't try to come and start the same nonsense over again when it's already been settled. Now, when the victim survivor is looking to cure, they are responsible for the reasonable costs, which is $100 or less, that is incurred by the secured party to enforce the agreement, which means they need to make full payment of those overdue payments plus $100 or less, depending on what money it took to file that action or to serve that notice of repossession. So say they sent it via certified mail, that notice, and it cost them $14, you might be liable for $14 then to make sure that you're including those costs. But again, it can't exceed $100. So if they used process servers that incurred $3,000 to try to find you, which would be quite an insane amount of money to serve someone, again, they're going to be able to recoup $100. That's what's reasonable under the statute. And again, this will suspend the right to seek repossession. So it will stop that proceeding in its tracks if you are able to cure this default in some way or another, either by making full payment or by making a creative settlement agreement with the secured party. All right, next is reinstatement. So reinstatement of a manufactured home is a slightly different kind of remedy. Reinstatement means I'm being able to go back into the home and I am able to be basically retitled, or not retitled, that's the wrong language, to reinstate your right to that action. So there's a 30-day period for this as well, right? There's specific language required as well under this. Minnesota statute section 327665 sets out that language, but the cost for reinstatement might include arrears, which again is that overdue payment and insurance, delinquent taxes, cost of services, filing fees, and potentially attorney's fees that are not allowed to exceed over $150 or half the attorney's fees authorized by section 582.01. So this will again allow someone to pursue a remedy out in court that it allows them to get back in the home. It allows them to be reinstated on the mobile home. There is specific language required. Payment is required, which is a big inhibitor to a lot of individuals, but it is a possibility under the law. So just know that that is also an option for individuals who are facing issues with mobile home is reinstatement. Repossession is, again, I'm taking back the home. Reinstatement is they don't have necessarily the right to the home, but I'm putting my name back in after paying this loan, or not loan, paying this overdue payment. All right. So evictions come up in mobile homes as well. It is the typical process. But a park owner has to have just cause for eviction. So you can't just evict someone for any reason. You have to have just cause. Now, someone is able to redeem. That means I can make those overdue payments just like you would be able to a landlord and stay in my home. There is a catch here. You can only do it twice in a 12-month period. So for someone who is falling behind a lot on making those payments on their mobile home or lot rent, that's going to be a lot tougher case, right? If you're happening 3-4 times in a year, this isn't going to be available to them after the second time. If they're not able to make those payments, right, but they want to make sure that they keep their interest in that mobile home and they know they have to get off the land in the trailer park or in the rental lot. They can ask the court for what's called a conditional writ. That means that they can stay on the rental lot for 60 days to allow them to sell their home and get it off the lot. That's if you can't move it on your own or something like that, but you can ask the court for permission to do that and they can grant it. And it gives you a little bit of time to figure out what to do and also allows you to hopefully get some equity out of that house, even if you know you're not going to be able to pay the landowner for where you were having the mobile home. Now, there are some specific requirements for park owners to evict people. One is under non-payment of utilities. Now, if someone who's living in a mobile home is not paying for their utilities, they're not paying their gas, their water, their electric, whatever it may be, the park owner has to give at least 10 days notice and an opportunity to cure, which means an opportunity to basically pay those overpaid expenses. If there are park rule violations, first of all, the park rule would have to be upheld as permissible under Minnesota law. There are certain park rules that are not allowed that we don't have time to cover today, but there are plenty of park rules that are allowed. And so again, if they violate a rule, they need to have a 30-day notice to cure. This might include something like not being able to have certain things on your lawn according to the contract that you entered into for the lot. And so the notice to cure would say you have to remove those things that we say you're not allowed to have within 30 days. And if you don't, then we can pursue an eviction action, right? Same with endangerment and substantial annoyance. We also have that 30-day requirement there. So that's if the landlord would give you notice that either your conduct is endangering other people, right? If you are having very dangerous conditions at your home, if you are hosting giant bonfires that flame into the sky and almost reach your neighbor's property, that's probably going to be an endangerment issue that your landlord would be able to evict you for, right? Or substantial annoyance, right? If your household is always loud at a huge decibel that other people around you are not able to enjoy their mobile homes, the landlord could also evict you for that. That allows for a 30-day notice to vacate. So you don't have the opportunity to cure if you hit that standard. But again, endangerment or substantial annoyance aren't little things. Under the law, they're substantial. You have to show that your conduct is endangering other people or that it's so annoying to other individuals that they're not able to enjoy their home, right? If a baby crying at normal hours of the day and night is not a substantial annoyance, even though some people might argue that it is. That would be something fairly normal. But again, if you have a professional DJ in your household at the loudest speaker available, that might qualify as a substantial annoyance depending on the decibel level. So just know to flag those issues when you're seeing them and to see, does it feel reasonable to you, right? Does it feel reasonable if someone came to your house and said, you can't do this, that you'd think, oh yeah, this is affecting my neighbors pretty poorly? Or is it, oh, well, that's just a pretty minor thing that happens fairly standard in most common living areas. I don't get how that would be something that would be able to evict them for. Use your common sense there and kind of see if you can figure out if it would be endangerment or substantial annoyance. And then, of course, give us a call if you'd like to talk that through further. But it does have to be a very big kind of annoyance or endangerment condition. All right, so defending against an eviction. This is similar to what Raylene already covered for our rental unit section, but issues to raise would be retaliation. So if you were being evicted because of your status as a victim survivor, not allowed. We're going to keep reiterating that. That is not allowed because it happens, and it is so frustrating because victim survivors think that that's legal, and it is not. It is not legal, it is not permissible, and I would like to shut that down as soon as possible when I hear it. Again, reasonable accommodations. Under the Fair Housing Act, housing providers have to provide certain reasonable accommodations to individuals who are disabled. So if a tenant or a person requests that they get a reasonable accommodation, maybe they need their driveway slightly extended because they need a specific kind of vehicle for their mobility to sit in that driveway. That could be considered reasonable potentially. Maybe they need specific type of railing to get up to the mobile home themselves. That could be considered reasonable. It really depends, but you can't evict someone based on a refusal to provide reasonable accommodations under the Fair Housing Act. It is not allowed. There are also defenses that you can raise. So one that is easy but doesn't come up as often is a defect in the notice to cure or vacate. Basically, they didn't provide notice correctly. So they don't get to proceed forward because they have to provide notice correctly. So if they provided notice 29 days before and the statute requires 30, that's a defect in notice. They have to serve it again and they have to wait that full 30-day period. That is required. Or if it didn't include some of the mandatory language that is needed, that would be a defect in a notice. That would be an easy defense to bring up in an eviction action. Habitability issues from the park owner, right? Maybe they're not providing water. Maybe they cut off your electricity. Not allowed. They're not allowed to do that. In kind of a retaliatory way. It's you could bring that up in an eviction action of, well, the reason I didn't pay my lot rent is because they shut off my water, and I told them that, and I'll pay the court in escrow for this, but that is the reason. That's not legal. So why would I continue paying them while they're committing illegal acts against me, right? That could be a possible defense. Same thing with unreasonable rent increase or improper rent increase notice. So things to flag are if their lot rent increases a substantial amount that does not seem reasonable, that's something to possibly look into. Or finally, that the rule leading to a violation was unreasonable or inapplicable to the resident from the park owner, right? So this is when we're talking about that and park rules and whether or not they violated them. If the park rule is not legal under Minnesota law, that's an easy way to get it ousted. Otherwise, if the rule is unreasonable, maybe they say you can't have lights on from 10 p.m. to 8 a.m. Is that a reasonable thing? We have to evaluate based on the circumstances, but my gut feeling would lead me to say no, right? So um, all things to look into and kind of use your common sense, and then again reach out to us to see what those legal remedies might be. But it's kind of things that you might think of anyways. of why this is not fair or why this is not just. These are just the iterations of fairness and justness as we have the standards in our current law.
And just as a side note, there are particularly, smaller landlords or, individual landlords will put some wild stuff in their leases and rules and things like that. So just take a peek at those. It's always, and then we can evaluate whether they are reasonable or not.
Exactly. All right. So, other possible remedies. Eviction of an abuser. You'd follow the standard Minnesota Statute 504B process. So, again, this is if you are living in a mobile home or a victim survivor is living in a mobile home and they're looking to evict their abuser, you'd follow that process where you have to give them proper notice and things like that. But you can evict them if you follow the right process. One thing we've seen fairly frequently and recently is unlawful lockout, where people change the locks on a home, or the ouster also includes like shutting off utilities that makes the home uninhabitable, right? So if a landlord decided to shut off your water, that's pretty extreme, and it's really hard to live in a home without water, although I know we've all seen individuals try to do it and do it because they have to. But it's not allowed to just do that without reason or basis. And so you can file what's called a petition for possession of rental property after unlawful lockout. And you can basically say, they locked me out of this home. They had no right to do so, and I need to be let into the home immediately. The courts handle those requests fairly quickly, as they are supposed to, and it's supposed to be a really quick remedy to get back in the home. And often the courts will also direct law enforcement to assist in that. So if the person who locked a victim survivor out is refusing to provide a key or refusing to do it, then the cops can come along and bring a nice handy gear to snip the lock and you can be let in. That's the court's order, and they're allowed to enforce it in that way. Another remedy is something that doesn't come up very often, but is certainly an issue, is conversion or closure of a mobile home park. So if they are closing that mobile home or changing that park, victim survivors do have some options. One is there's a manufactured home relocation trust fund in Minnesota that helps victim survivors, and not specifically victim survivors, but in our case, in our circumstances, who we are looking for, to receive compensation to relocate, right? So if a mobile home is closing and they think, or a mobile home park is closing and they think, I don't have anywhere to go, there might be some funds available to them from the state to help them relocate, which is great and a huge resource that I think people need to be using in these circumstances. The other thing is they need notice of the closure and proper notice at least 12 months in advance to all residents. So if a mobile home park owner said, tough luck, I'm moving to Florida, I'm selling this park to the highest bidder, and you all need to be out in 6 months, that's not allowed, right? Need at least 12 months notice for it to be effective under the law. And then again, hopefully we can work with victim survivors to safety plan and find some opportunities for them, possibly through this manufactured home relocation trust fund, to help them stay on their feet while they're navigating this pending housing issue. All right. Then contracts for deed. We have been getting a lot of questions on contracts for deed lately. I don't know what's in the air. I don't know what's been going on. But Raylene and I have done a little bit of a deep dive to figure these out more extensively just because of the amount of questions we've been getting. So first of all, what is a contract for a deed, right? Many people might not know what this is. It is a purchase contract for real estate, but it is different than just buying a home with a purchase agreement and a regular mortgage, right? Instead of paying the seller all at once, like you do in a mortgage, when you get the big loan from the bank, you pay out the prior owner and then you still owe a bunch of money to the bank itself, right? Instead of doing that, you're paying a seller over a period of time, think around 3 to 5 years, there's not a set strict time period, to pay for the equity in that house. It can be a great way to enter into homeownership for people who aren't able to qualify for a mortgage for whatever reason. And traditionally, when it's done person to person, where maybe you have a second home you inherited and you don't want it anymore, but you know a nice young family who's not able to qualify for a mortgage, but they can make monthly payments to you to get equity in the home. It might be a possible arrangement to enter into and benefit everyone, right? You're getting slow equity out of the home, they're getting a place to live, and they're gaining equity in the home. That's wonderful. However, these can be fairly predatory in nature. There was recently law passes we're going to talk about in a little bit to shift some of those predatory behaviors and protect people a little bit more. But there are heightened risks under contract for deed homes. Mortgages require a foreclosure process. Foreclosure can take a long time. There's typically a right to try to intervene and pay off the foreclosure debt. There's a lot of things you can do in a foreclosure process that you cannot do when you're dealing with a contract for deed property. So again, it's a different way to finance a home, but there's a heightened risk of losing all equity in the home. Often, there's a large balloon payment required at the end of a contract period that people don't always see in the contract they sign. So essentially, they think, oh, I just have to pay this monthly payment of $2,000, and after 5 years, I'll own the place. But what they didn't see in the fine print is that in the last month of that 2 year period, they are required to pay $50,000. And this often requires people to take out a mortgage or a loan to satisfy that big balloon payment. And it often comes as a surprise to people because it's not what they traditionally think of when they're thinking about those contract payments they're making on a month-to-month basis. So that's something to look out for. At the bottom, I have put the Minnesota Attorney General's contract for deed guidance on this, just because I think it can be a helpful resource to look through and see if those issues are present and what you might be dealing with. But it's a great resource to use, and so feel free to click on that and utilize that when you're dealing with clients who are calling about contracts for deed. So contract for deed, you can switch to the next slide, Raylene. Yes. Okay. So the seller can cancel the contract if the buyer has failed to make a payment. Basically, this means if you fail to make one of your monthly payments, the seller can say, well, I'm done with the contract. They don't have to, right? They could give you a break. They could be accommodating and kind. But if they want to get their equity out of the home and they're not sure you're going to make the next payment, they can immediately cancel the contract when you've failed to make payment. Now, when I say immediately, I don't mean that everything's done and gone, but they can give that notice saying, I'm canceling the contract if you do not do these things. First, they have to serve the buyer with that notice of cancellation. So the contract for deed needs to be in writing, right? And they have to serve a notice of cancellation for that written document. There's a 60-day cancellation period for the buyer. They need to pay the seller the money needed to catch up on those payments or cure the default within that 60-day period. If they're able to do so, then they're fine. They've redeemed themselves, they're still operating under the contract for deed, and their equity is preserved. The problem is if they're not able to do that, right? After 60 days, if they have not paid to catch up on those overdue payments and cure the default, they can be evicted from the home, which is a very serious thing that happens to a lot of people. The biggest thing that people get frustrated with on these calls when I'm talking to them about them is that they cannot recover any payments made or equity generated in the home. Now, that is often the assumption when we're talking about rental units, right? Because you're not gaining equity when you're renting. You are just paying someone for the right to possess a home or a residence during that period of time. You're not expecting to gain equity. With a contract for deed, the whole goal is to own the home at the end of the contract. And it's really frustrating to people that all of a sudden, if they don't make payments and they don't cure it within that 60-day period, any money they've paid is gone. It's gone and they have no right to the property anymore. And they also have no right to that money, which is why these can be fairly predatory in nature because everything can be yanked out from under an individual who's under a contract for deed and in a very short window of time. Like I said, foreclosure proceedings take time. This is 60 days. That's 2 months. And that is not a long period of time to catch up on payments, especially if a victim survivor is facing financial abuse or other financial difficulties just as a result of their abuse or the circumstances that they're currently in.
And I think this can sometimes, a contract for deed can look really appealing to someone who has been, experienced housing instability for a long time, because it's like you're paying essentially rent, what feels like rent, for a period of years, and then you own your home. But it's that balloon payment that gets really tricky, and some of these other practices that can be, like Bailey said, just really predatory and can be risky. So it sounds really awesome at first glance to a lot of people, but that finer print is really important to dive into.
Yes, 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 yes. All right. So, like we said, beware of scammers, beware of possible issues that come up in contract for deeds because they can be a great tool for home ownership, but they also can be utilized by a lot of people who are looking to scam other individuals out of money. There has been a history of real estate scammers who enter into contracts for deeds for homes that they know are already in foreclosure and they just pocket the money. Now, the buyer is not able to recover property in that foreclosure because technically the buyer is not a person who owns the home yet, right? They're hoping to own the home. They're hoping to get there at one point. But once the property is foreclosed on, that home is out of the market and gone. And that would only be able to be remedied if the buyer would be able to go and purchase the home separately at the foreclosure auction, right? That is not an easy feat to do. And often, if you're in a contract for deed, you probably didn't have the money to just pay for the home outright, anyways, like you would in an auction. Then a buyer would need to file a different civil suit for like unjust restitution or fraud to get the money from the seller back, which can be a long process. It's not guaranteed. I would say there's a strong claim if you have a written contract and you have documentation of the payments you made to this individual. But again, it's extra litigation that you have to go through just to get equity back from some place that you really shouldn't have had any equity in the first place because there was no interest in the home that you could buy to begin with, right? Home was being foreclosed upon. Best practice, research, research, research. Research whether a home is in foreclosure before entering into a contract for a deed. If the home is not in foreclosure, then it should be safe. But if it is in foreclosure, then there are a lot of risks that you're entering into unless the foreclosure process is ended without a final foreclosure auction on the home, right? All right. So, like I said, the law in Minnesota was amended in 2024. Well, it took effect, I should say, on August 1st of 2024 to really change contract for deed legislation in Minnesota. And this was the most significant change in contract for deed law from the Minnesota legislature in almost 4 decades or 40 years. So it's a big overhaul and it's intended to protect people from predatory issues that we've been seeing in the past. So some of these new requirements are that sellers entering into residential contracts for deed have a non-alterable, meaning they cannot negotiate around it or change it, obligation to pay any delinquent real estate taxes on the property. So when you're entering into a contract for deed, there can't be delinquent or overdue real estate taxes on that property, and they have to record the contract for deed within 4 months of execution. And that is to make sure that the registrar in which that the county or in which the property for the contract for deed is located knows that this contract for deed is going on to provide a little bit more stability, predictability, and recording of these issues so that people might have better legal options to pursue afterwards. If they do not do this, if they do not pay those delinquent real estate taxes, or they do not record the contract within 4 months of execution, and execution in legal sense means both parties signed the contract, they might not be able to cancellate the contract for a deed, which would be a huge benefit to a victim survivor. So it's really important to look for that and make sure that that's not happening because if they are using those predatory practices, people do have options. The second big new requirement is the definition of what an investor seller is. Now, there is now this presumption in Minnesota that any seller under a residential contract for a deed, and when we say residential, we mean a home meant to live in, right? Unless the seller qualifies for an exemption. So we're starting with the assumption that you are an investor seller if you are selling a contract for deed home. And that is basically saying we're starting with the assumption that you have additional things you need to do unless you can prove you're one of these 11 exceptions to make sure that people are protected under the law. Those 11 statutory exemptions, I won't go through them, but they're defined under Minnesota statute section 559A.01 subdivision 5. So if you want to look those through, it does, investor sellers are not typically like the people-to-people transactions that I gave earlier where you inherit a house that you're not going to live in, but you'd love to sell it to a family who can't qualify for an immediate mortgage, so you enter into a contract for a deed. That wouldn't be kind of the investor seller that we're looking for. This would be for individuals who are snatching up properties and trying to do this in a more predatory sense traditionally. So if you are considered an investor seller under Minnesota law, you are required to you are required to provide the buyer with a detailed disclosure notice specifically highlighting balloon payments. So this again is to protect people, to highlight this is a big payment you may have to make at the end of the contract, and you have to make sure it is highlighted so that people aren't sneaking this language in and finding out later that they're going to lose equity because they can't make a $50,000 payment 1 month at the end of the contract. I use 50,000 not because it is any kind of real number, but just because it is a high number that I would be very shocked to have to pay at the end of a monthly normal payment that's more similar to rent, right? So that is not a magical number. That is just what I'm going to keep using. And they also have to disclose the amount that the investor, seller, or related party paid to acquire the property. So you kind of know what it's worth, and they can't be selling it for an insane amount more than what it's worth unless you really agree to it, but at least you have that information to make an informed decision. It also has to have a detailed amortization schedule. So showing how are these payments made to obtain the deed to the house? How am I making payments under this contract? And that is required of investor sellers to better protect buyers. All right. So next we have common contract for deed issues. Biggest issue we see is failure to make payments. That is the biggest issue we see. There are some options that you might have. One, again, sometimes settlement negotiations are the most flexible option for people, especially if the seller is willing to work with them. Oftentimes, sellers just want the money out of the property, right? They want to get the equity in the property. And so if you're able to negotiate, I can make this payment. It's going to take me a little longer to make this payment, but I can certainly do so. And if I'm not able to, then I agree that I will leave the property on this time, right? Those could be agreements you can enter into that can allow for some more flexibility with a buyer. You could also get a loan to make a payment on the home. So if you're able to qualify for a loan and you just really need that money, that is a possible option. Obviously, it isn't always desirable because people in these circumstances don't often have the means to just apply for additional loans and get additional money, but it is an option. Again, if the parties are married and someone is refusing to make those contract for deed payments, which is an issue that has come up frequently for us, you can ask for relief from the court in a divorce case through temporary support motion. You can also evict an abuser. You are not able to evict them if they are a party to the contract for a deed, right? So that would be a part of the problem. We're actually in discussions on some possible legislative changes to see if we could shift that, but there is nothing certain. So that is where the law stands right now. You are not able to evict someone if they are a party in the contract for deed. If the abuser is not on the contract, though, then our typical eviction process governs. So again, that would be providing proper notice. There is some safety planning required because during that notice period, they would still technically be allowed to live in the home. And so making sure that victim survivors are protected during that time is very important, but you can evict them if they are not on the contract for deed. Safety from an abuser. An order for protection is a possibility. Just name the contract for deed house as the protected residence, and the abuser could be restricted from coming to that residence if the court approves it, right? Again, you could also apply for a harassment restraining order, but this is only if the abuser does not live at the home. And again, for an order for protection, you need to be a family or household member, and you need to have allegations of domestic abuse. Harassment restraining order, you need oversimplification here, but you need to either have one incident of sexual assault or repeated incidents that lead to concerns for the safety, security, and privacy of a victim survivor. So just things to note there. I know we handle those every day, but I just like to make that distinction because they are not the same, even though they often are interchangeable sometimes in the work for protections that we need. Finally, if the abuser retains an interest in the home, once the contract for deed has been satisfied, right? Once the buyer or buyers, plural, have made all payments under the contract for deed and own the home, you can then ask the court for a partition action if the property is affixed. So if you buy this home and you have full interest in it with an abuser and you want to get your money out of the home, that's when you file for partition again. But it can only happen once the contract for deed has been completed. You would not be able to file for partition while that contract is still being played out. So one last question that we frequently get, personal property. Now, this doesn't specifically necessarily relate to housing law, but it is something that comes up in a housing context very frequently, so we wanted to make sure to cover it. Personal property is different than real property, right? We covered a little bit of that difference before. Real property is like real estate. Personal property is any kind of property that's either movable or even intangible, like a retirement account, that an individual can own. So it's not land, it's not anything permanently attached to land, like a home, but could be pretty much anything else. Could be a vehicle, could be a dresser, could be a mirror, could be anything. Questions to consider for next steps on personal property in the residence. Does the survivor have access to the home, right? If they do, then they can take their personal belongings so long as the abuser doesn't have an ownership interest in them, right? If they know that's my TV, I brought it here, they didn't pay for it, it's what I brought to this home, if they have access to the home, they can take it. Now, if they bought the TV together, that might complicate things a little bit more, but there are still options. Another question is, does the abuser have access to the home, right? Are they able to access any of this property? And is there a need to get that property out sooner than later? I can't tell you the amount of divorce cases I have handled where people damage other people's property as a means to harm them. And that can be really frustrating. So that is a question we need to ask and plan for whenever we're considering next steps. Again, if we are dealing with married couples, you can address this in the divorce process. You could either ask the court for a temporary motion to allow you to retrieve some personal items that either you believe that an abuser might try to destroy or things that you need, right? You could say, I had to flee this home. I wasn't able to take many things with me. I would like the opportunity to go back to the marital home and take my toiletries and my clothing and the things that are kind of basic essentials I need and figure that out. For more pieces of property that aren't necessary to your day-to-day living, like clothing, like toiletries, it's likely the court will address that later on in the final dissolution if you guys aren't able to come to an agreement. But the court can divide up that personal property. They can say this person gets this dresser, this person gets this bed set, this person gets this lamp, right? You'll want to make specific claims in the divorce process to which personal property you would like to make sure the court knows about it, because the court doesn't know any more information than you give it. So if you don't provide, I have these paintings that my mother passed down to me for generations that I need to get out of the home and are my non-marital property, the court's not going to know about them, and it's likely not going to be in the divorce decree, and it's going to be hard to get those things back. But if you specifically name them in the divorce process and say, these are the things that I believe either are my non-marital property or the things that I want that we jointly share in the marriage, the court then can make an informed decision and divide that property up however it sees justice requires. And in family court with the divorce process, that means that the property division needs to be fair and equitable. So it doesn't mean equal. So you could ask for more of the property if you felt it was more fair and equitable to receive it. But just know that's kind of the legal argument you would need to be outlining there. If people are not married, you will need to address it in different ways. One could be in housing court, right? You could say, if there's a pending eviction case, you could say, I need to be able to get my things from this home. I will leave the home, and it's fine that I'm being evicted. I don't challenge the eviction, but I do need to be able to gain my personal property back, right? Conciliation court claim. So if they're still retaining on to this property and you're not able to retrieve it, you can ask for specific performance in a conciliation court claim. Specific performance means you can ask the court to direct specific actions in regards to what the other person does, like allowing access to the property, like bringing you specific items that are yours, like retrieving those items yourself, right? So conciliation court, as long as the property is worth less than $20,000, would be the proper way to address that if you're not able to pursue it in housing court. If the personal property is over $20,000 in value, then it would need to be a civil lawsuit to address it as an unmarried person. So if we're talking about getting a car back that has a very high value, that might be something that commonly comes up with a civil lawsuit of retrieving that. But again, these are issues that Raylene and I are happy to talk through if you have specific questions on them. We just wanted to give a high overview on what this personal property might look like, because we do have a lot of calls for people trying to get their belongings back and looking for the legal ways to do so. Right. So we're wrapping up a little early because I did want to allow for some questions. I know we went over a ton of information from mobile homes to contract for deeds to houses to apartments. Does anyone have any additional questions that popped up that we can help answer?
And maybe we have answered all of them or have confused you so thoroughly you're not quite sure yet. Either way, we're here for you. So you're always welcome to reach out. Thanks for sticking around with us. We actually went a little over, so sorry about that. But we're glad you got to hang out with us for the day and help us think about economic mobility for victims and survivors. I know some of the remedies are really awesome to learn about. Some of them feel really kind of like a huge mountain to climb. But there are some really good ways to think about long-term economic mobility for folks. So Bailey, thanks for giving us that big overview.
Thanks everyone for coming. It was a joy to talk with you, and we'd be happy to talk with you more if you do have questions in the future.
And Anna Maria, you are muted. So if you wanted to share anything with us, you should unmute. But Anna Maria says goodbye, everybody. Thank you so much, everyone.
My audio is off. Yeah. Take care, everybody. We'll see you soon. Thanks.